So you've been through the meat grinder of getting a order granting you possession of your child. But the other side does not honor that order and parentally kidnaps your child, doesn't return your child for 1, 2, or multiple months. What's your remedy? Your remedy is the extraordinary relief we call the writ of habeas corpus. And that's the topic of today's video. The writ of habeas corpus is an extraordinary relief. In other words, we don't really do it much in family law except in the most extreme cases. And the writ is literally Latin for show me the body. We mostly see it in criminal cases where somebody's trying to bond out or somebody's trying to get released from prison or some other unjust incarceration. But the Texas Family Code provides a vehicle for a person who has the right to have a child to use the writ of habeas corpus to force the other party who's illegally restraining that child against a valid order, force that person to bring the child to court, and the court will decide who has the superior right to have that child. And if the person who is asking for the writ can prove 4 elements, which is 1, that they have a superior right under a valid order. 2, that the child is being illegally restrained by the other person. 3, that the person asking for the writ didn't voluntarily give up the child, like outside the order. And 4, there's no other reason why the child shouldn't go with the court-ordered possession. Then, if you meet those 4 elements, then the court must sign an order returning the child consistent with the order that was previously done. So, the writ of habeas corpus is a valuable tool to use in instances where we have, for example, parental kidnapping. Although it can be used for any person who has illegally taken your child who doesn't have a legal right to have your child. So one caution on this is it's an extraordinary relief. In other words, it's not one of the ways normally that you can correct a problem with a order. If your order is not in the best interest of the child, or you think there's a reason your order needs to be changed, then a modification might be the kind of action that you want to take. If they are just not returning the child for, on time during their scheduled time with them, or if they're constantly late or things like that, then you might want to do an enforcement action. But if you have an order and the other parent or any other person is taking your child and not giving you any contact and you don't have any access to the child, then a writ of habeas corpus might be the appropriate remedy for you, as long as you can meet those 4 elements. So you got to prove that the order is in existence. You got to prove that the order is valid and current. You have to sort of you have to prove that there's no other proceedings going on that might make a writ of habeas corpus not appropriate remedy. Like if there's already a court proceeding going on, then this isn't the remedy for you. But you've got to show that the child is supposed to be with you. There's nothing else going on to say otherwise, and the other person who's illegally restraining your child just refuses to follow the order. So you file the writ of habeas corpus. It's issued. You have a hearing, and as long as you meet those 4 elements, the court must order the child returned to you. And again, this is not going to be a rehashing or a relitigation of the custody. If the other side wants to start arguing about, the child is better off with me or anything like that, you need to have that shut down, because that's not what that hearing is for. The hearing is only to show who has a superior right to have the child under the court order, a previous court order. So now, if you get the relief, if you get an order returning the child, then that's great. But sometimes people will not follow any order at all, even if you get another order enforcing your other order, and you can't get physical custody of your child because the other person just is not going to follow the orders. What can you do then? Well, there is one final move that you can make, one final tool in your belt that you can take out, but it is very harsh. It's very extraordinary relief and we just don't normally do it because it requires a sheriff to go to the home of the person who's violating the order and physically take the child and bring the child to wherever the court says, like usually the other person's address, and surrender the child to. So it can be a very traumatic experience for a child to have a police officer come and pull them out of the home that they might have been in for several months and then bring them to the proper custodian. But it may be necessary if the petitioner is not cooperating. Not the petitioner, the respondent is not cooperating. Maybe the only thing left that you have to do, and that may be ultimately what's best for the child. They have to go through that traumatic experience, but it shouldn't be done lightly, is what I'm trying to get across. And it should only be done as a last resort. That's the writ of attachment. So again, writ of habeas corpus means show me the body, and it may be a way for you to get access to your child when another person is illegally restraining your child from access to you if you are the person who should be caring for the child. So if you have any questions about that, please give us a call. We'll be happy to answer any questions that you have.